Everybody. Thank you very much for coming. My name is Scott Duke. I'm a lawyer with the Federal Department of Justice office here in Yellowknife. I've lived and practiced law in Yellowknife for approximately 29 years, a little less than 3 years. I'll insert the standard disclaimer here. Nothing in this presentation and none of the views I express today are those of the Department of Justice or the Government of Canada. So thank you for coming, everybody. I hope everyone is well and keeping healthy during these times. I'm always very pleasantly surprised and I'm quite flattered when this presentation brings out this many people. So thank you very much for that. My hope today is to give you some sense of the evolution of law and legal institutions in the NWT from 1670 to 1955, which we can consider to be really the start of the era of the modern Supreme Court of the Northwest Territories. I think that many of us, when we start practicing up here, certainly I was this way, we either don't think about how these institutions and how the law developed up here. We don't think about why things are the way they are, why they're different maybe from the jurisdictions we came from or practiced down south. And we may take those for granted. I think a lot of people come up here and they simply assume that things are done up here either like the province they came from or like some other province. However, we also learn that that's definitely not the case. And if there's a theme for this presentation, I guess it could be, like so many things about the North, that it's different up here. And there are very good historical reasons for that. I think another theme of this presentation is, as you'll see, the development of law and legal institutions up here is by no means considered and deliberate and thought out. It's reactive, not proactive. And as one of our former prime ministers said, referring to the governance of the Northwest Territories generally, Canada has always governed her territories with an absence of mind. And I think that that's doubly true of evolution of law and legal institutions up here. I'm going to cover about 350 years of history in a little less than an hour. The Law Society have my speaking notes and they've made them available for this presentation. You can ask me or Glenn or Bob for a copy. We'll be happy to give it to you. I do hope to leave some time at the end of this for any questions or discussions if people have any. So, 1670. We start in 1670 because that's the HBC era. HBC, everybody knows what I mean when I refer to HBC, Hudson's Bay Company. Or as an old Inuit fellow told me once when I was in Pangertung many years ago doing a circuit, we were walking around the town and we came across the old HBC post there. And it was the interpreter for the court party, and he asks me, so you know what HBC means? And I said, well, yeah, Hudson's Bay Company. And he shook his head and he said, here before Christ, sonny, here before Christ. They weren't here before Christ. They got here in 1670. But before the HBC got here, before there was really extensive European contact or any sort of control in Rupert's Land or this part of Canada, there were laws and legal institutions in place. Those were the traditional forms of governance and law that were employed by the Dene and the Inuit people who lived here. And even after the Hudson's Bay Company arrived, those forms were largely left untouched, especially as they related to relationships between the Aboriginal people themselves and even in some cases between those people and the Hudson's Bay Company and their employees. So 1670, the Hudson's Bay Company arrives in what was then known as Rupert's Land. They have a charter which has been granted to them by the British Crown, and that charter gives them, among other things, the privilege of exclusive trade within the area now known as Rupert's Land. Rupert's Land, there are various definitions and geographic areas that have been assigned to that. Basically, what we're talking about is the watershed of the Hudson's Bay, a little bit inland, but not too far, because very little of the inland of North America is known at this point. It doesn't, interestingly, include much, if at all, of what we consider today's Northwest Territories, but it did amount to approximately a third of Canada, what today is known as Canada. The privilege of exclusive trade in the Hudson's Bay Charter also brought with it an exclusive right of judicature. So not only was the Hudson's Bay Company the only corporate entity that could trade not only with Aboriginal people, but with other people in this new land. They could set up trading establishments, they could set up trade routes, they could basically do anything they needed to establish and enforce an exclusive right of trade. Part of that was an exclusive right of judicature. They could apply law as they saw fit, and they could create whatever legal institutions that they saw fit to apply and enforce those laws. The only real limitation on that in the Hudson's Bay Company Charter is that those laws, quote, had to be reasonable and not repugnant or contrary, but as near as may be agreeable to the laws, statutes, customs of this our realm. So in other words, English common and statute law as it existed, July 15th, 1670, or certainly not inconsistent with that, in conformity with that. The date of the reception of the law, as I said, is July 15th, 1670. While the Hudson's Bay Company has the responsibility for administering these laws, setting up the legal institutions to administer and enforce these laws, they do not have the power to make law themselves. They are still just a company, even though their powers under the charter are broad. The power to make those laws still rests with the imperial government in Britain. This is why data reception becomes important. And I had a question about this in the last presentation, so I'm just going to expand on this a bit. Because the Hudson's Bay Company could administer and enforce law, but they couldn't make it, the imperial government, the controlling authority in Britain, had to basically tell them which body of law they can apply and as of what date. So the body of law they apply is English common and statute law, and the date of the law, of that law that's effective, is July 15, 1670. This works because it's synchronous with the date of the Hudson's Bay Company Charter. It causes huge problems later, and the early part of the evolution of law and legal institutions in the Northwest Territories is really marked by a lot of confusion over what does that jurisdiction mean, where does it extend, and what about this date of reception anyway. Now, neither the Hudson's Bay Company or the British government does much by way of applying law in this new territory, in Rupert's Land. They're just not inclined to. Costs money, got to set things up. The Hudson's Bay Company really is not interested in doing that. They don't want to spend money on that. They'd rather concentrate on the fur trade, as was then starting. The other problem is they can set up courts, but they don't set up courts for a number of years, as we'll see later. So if they are going to apply and enforce British law, for instance, in a criminal case, you're going to have to arrest someone, clap them in irons, transport them down to the nearest superior court, probably Montreal, because that's where the HBC headquarters are. transporting someone to Rupert's Land to Montreal is not practical. They're just not going to get into that. So unless it's very, 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 very serious, think murder, the HBC is not really that interested in getting in the law enforcement business. The other problem is this issue of jurisdiction. Where exactly does this apply? It starts in Rupert's Land, but of course, as the Hudson Bay Company expands their empire, as they require First Nations and other Aboriginal people to get them further, going farther and farther and farther inland, really beyond the boundaries of what would be considered Rupert's Land. Issues of jurisdiction arise. Does the law still apply? Does the charter still extend its jurisdiction? I won't go into the details of this. It's in my notes, but between 1803, 1821, there are a number of attempts to clarify the jurisdiction of the courts of Upper and Lower Canada and extend those beyond Rupert's Land into what are called then the quote-unquote Indian territories. However, date of reception of the law that gets applied is still July 15, 1670. That doesn't change, even as the years go by. HBC doesn't all this time. They never really create anything like a court. It's all done by factors in Hudson's Bay Company posts. But again, there's really no real desire to get into this and no perceived need for anything like a court system. They provide for it in 1821 for the very first time with the merger of the Hudson's Bay Company and the Northwest Company. Again, consistent with the theme of this, they don't actually get around to creating an actual court until 1835, and that's called the General Quarterly Court. This is called a court. It's not really a court. There are Hudson's Bay Company employees who are appointed to this. Some of them have legal training, some of them don't. There are still issues of jurisdiction. They are still applying the law of England, common and statute law, as of July 15th, 1670. So neither a court without proper judges who have tenure applying law that by this time is 150 years out of date, it's really not adequate for the growing territory. The General Quarterly Court is headquartered in what was then the Red River settlement. That was not the biggest, but certainly one of the biggest settlements in the Northwest Territories. Again, a significant post for the Hudson's Bay Company. And it's becoming more of a territory and less of a frontier at this point. It's becoming more of a political jurisdiction within a country and less of a frontier that's being governed by a mercantile company at this point. But as we see, the law and the legal institutions that are permissible at this time really aren't matching these needs. You've basically got 17th century law and legal institutions trying to adapt to a very, very increasingly complex 19th century frontier society. This all changes in 1870. And why? Well, because 1870, at least for the Northwest Territories, is the beginning of huge political and constitutional changes. First of all, Canada acquires Rupert's Land and the Northwestern Territory from the Hudson's Bay Company. I mean, the UK government acquires it, but it's transferred to the Dominion Government of Canada, as it was then called. So Rupert's Land and what was then called the Northwestern Territory are now part of this new country of Canada. So the Dominion Government of Canada now has full and plenary authority, legislative authority, to legislate for this new territory. At the same time, legislation is also passed to create the first province of Manitoba in 1870. This is what I call the postage stamp size province of Manitoba. a very small square one that came as a result of the first Riel Rebellion in Manitoba in 1870, and also which created the post of the first Lieutenant Governor of Manitoba. That Lieutenant Governor has the power to appoint judicial officers. And the first officers he appoints are the previous Hudson's Bay Company judges, and he appoints them as JPs. Actual legislation for courts and the appointment of judges doesn't come along until 1873. And that's the first time in the Northwest Territories, that's the first time in its history that courts, legislation creating courts and a court system and everything that goes along with that court system is done by a Canadian legislative authority, 1873. At the same time, this legislation also creates the Northwest Manitoba Police, which becomes the Royal Canadian Mounted Police. The court that this legislation creates are stipendiary magistrates. They've got very limited jurisdiction. They promulgate the first criminal procedure rules, a few civil rules, but not that many. And in these criminal procedure rules, they include for the very first time the duty of the Northwest Manitoba Police to attend every sitting of these newly created courts wherever they may sit in the Northwest Territories. I can tell you that this duty is observed even today. When I first came up here, one of the judges who is Supreme Court judges who was sitting on the bench was Mark DeWert, who himself had been an RCMP officer. We were on circuit in the High Arctic in Joe Haven, and it was the first day of the trial, jury trial, and the RCMP officer showed up in his uniform, and Judge DeWert was very quick to point out the duty under the 1873 legislation and the fact that that duty was still in force, and sent the officer home to come back in his red serge, as was expected under this 1873 order. The officer did that, not very happily, I can add. But Justice DeWert, at a minimum, has been of the opinion that that duty never went away. In 1875, for the first time, the Lieutenant Governor of the Northwest Territories gets the power to appoint stipendiary magistrates. It's not just the Lieutenant Governor of Manitoba at this point. And the only interesting thing about this particular stipendiary magistrates court is that this is the court that tries Louis Riel in 1885 after the Northwest Rebellion in northern Saskatchewan. That trial took place before stipendiary magistrate Hugh Richardson, sitting with Justice of the Peace Henry Lejeune, with a jury of 6, as was provided for in the criminal rules of the day. One final point on this court, coming out of the 1870 legislation, it was the Manitoba Queen's Bench Court that was the Court of Appeal for the Northwest Territories during this time. 1886, 1905, for the first time, we get a Supreme Court in the Northwest Territories. It's very short-lived. It has a very undistinguished history. Not much of note happens under that court. The important thing to note, however, under this legislation is for the very first time, the date of reception of English law in the Northwest Territories is now July 15th, 1870. Doesn't sound like a huge difference, especially coming in 1886, but it's a huge difference. And it, more than anything, more than even the creation of the first Supreme Court, that single decision does a lot to, in effect, modernize law and legal institutions in the Northwest Territories. Also keep in mind that this is done where you've got a federal government who's got legislative authority for the Northwest Territories, so they're no longer bound by the law that exists at that date of reception. They can make new law. They can repeal or replace the laws that they, in effect, import via that data perception. The other thing that happens under that court is we also get the first rules of court, the first complete rules of court, criminal and civil. I've got a facsimile copy of those. I'll hold it up. I realize that this is terrible on Zoom. They're not that thick. They're about 1/4 of an inch thick compared to certainly what we've got now. These are promulgated the 28th of January, 1895. And when you look through these rules, they're not dissimilar to what we see in our rules today. Just taking some examples at random, they provide for appeals. They provide for controverted municipal elections, something that's necessary for a growing territory where you're not just getting fur trading posts, now you're getting actual settlements in cities and towns. A set of forms, appeals under the criminal code, rules and orders under the Winding Up Act. A lot of these rules have to deal with rules and orders under the Winding Up Act. I don't know what was going on in 1895, but evidently they needed a lot of rules for winding up companies in 1895. Admission of documents, register and file of proceedings, attendance and appearance of parties, service of summons and notices, forms, costs, computation of time, general directions, and then a Supreme Court tariff at the back. Very similar to the rules that we have today. As I said, however, this court doesn't really last that long. It doesn't have a distinguished history, and it's dissolved in 1905 with the creation of the provinces of Alberta and Saskatchewan. So what happens in 1905? We go back to a stipendiary magistrates court, and that continues in force for another 50 years. In the bibliography to my speaking notes, I include a reference to Graham Price's master's thesis on the stipendiary magistrates court. I highly recommend that thesis to anyone who's more interested in it. Everything I'm going to tell you is based on Graham's thesis, but he goes into it far more detail. And trust me, even for a master's thesis, there are some great stories in there. To say the least, this court has a checkered and undistinguished history. It had very serious institutional impediments and constraints. It's widely perceived as an inferior court, especially by counsel. Speaking with Justice DeWert when I first moved up here and started practicing up here, he had nothing good to say about these courts. And he told me any number of times they simply weren't good enough for the territory that the Northwest Territories had become. And you've got a city of Yellowknife here already, albeit a small one. They're not judges, they don't have independent tenure. They've got no offices, they've got no robes, they've got no judicial staff. They're sitting in their own bureaucratic offices, whether they be federal civil servants or otherwise. Some of them had legal training, most of them did not. If you read Graham's thesis and run through any number of the cases, you can tell that they were anything from what we would call impartial. And the growing legal community in the Northwest Territories, mostly in Yellowknife at the time, quickly came to regard this as a very inferior court. They realized very quickly that the evolution of this territory demands more of an evolution, a further evolution of law and legal institutions. And the stipendiary magistrates court was just not the evolution that was needed. However, there was very little they could do about that. Again, absence of mind. This was not a priority. It certainly was not seen as a priority in Ottawa. There were certainly, there was not sufficient activity, population, legal disputes being generated up here, such that it required anything like a sophisticated court system, in Ottawa's view. One point to make about this court, though, is that there was a very limited circuit court associated with the Stipendiary Magistrates Court. It didn't exist everywhere in the Arctic. It didn't exist all the time. It existed basically at the behest of the Hudson's Bay Company and the RCMP because it relied on them for staff and logistics and transportation. Again, undermining the independence and the perceived independence of that court. The other thing to notice during this era, between 1905 and 1955, is there's no court of appeal for the Northwest Territories. Nothing. They're not provided in legislation or anywhere. Nothing gets done about that until 1943. In 1943, the Criminal Code is amended to provide that criminal appeals coming from the Northwest Territories can basically come before a court of appeal of any of the provinces. If it came from the Eastern Arctic, it went to the Eastern provinces, and came from the Western Arctic, it went to the Western provinces. In 1947, the NWT Act is amended to provide that civil appeals can go to an appeals court in any of the provinces. So this brings us to 1955. As I said at the introduction, this is really the era of the modern NWT Supreme Court and the modern NWT court system. This is when the final pieces fall into place, and we get what I think we can properly call is, you know, a legitimate, independent court system, court administration, and as we will see, because of the people who get appointed to those positions, we get courts that achieve, I guess, a bit more independence than Ottawa may have anticipated. The legislation to create these courts, again, in keeping with the theme of this, is passed in the early 1950s, 1952. The first judge, again, isn't appointed until 1955 to what is then called the new Territorial Court of the Northwest Territories. The Stipendiary Magistrates Court becomes the Police Magistrates Court. And this new Territorial Court is the Supreme Court for the what will become the Supreme Court for the Northwest Territories. Also at this time, a little bit later, we finally get a Court of Appeal designated for the Northwest Territories. That's the Alberta Court of Appeal in 1960 through amendments to the Northwest Territories Act. Again, 5 years later, after the first Superior Court's created. I'll give credit to this to Charles Davison, who's a local Yellowknife lawyer, and who had some questions for me after my last presentation on the evolution of the NWT Court of Appeal. I've touched on it briefly in here just because there's not a lot out there, and quite frankly, wasn't a Court of Appeal up here for the longest time. This is the first time as well in 1960 that we get, you know, not our own Court of Appeal, but we get an actual court designated solely as the NWT Court of Appeal. 1971, there's a bit of a renaming. Territorial Court becomes Supreme Court. Police Magistrates Court becomes the Territorial Court. So, 1955, the first judge is appointed, and that first Supreme Court judge, as I think most people know, is John Sissons. And, you know, again, it's not just the creation of the court in 1955, it's the appointment to John Sissons in 1955 that really sets the model for that court and really makes that court what it became. For the first time, you've got a formalized court system with its own inherent jurisdiction, and Sissons basically takes that as far as he can go. He formalizes a circuit court He very, very strongly believes in the old English adage deriving from their circuit courts that law should be taken to every man's door, that people accused of crime shouldn't have to travel to the court's door. And he does as much as he can, both in terms of the administration of justice, as well as his substantial decisions in adapting the law that applies in the Northwest Territories to the realities of the Aboriginal peoples who are living up here. In the bibliography to my notes, I include Sisson's autobiography. I highly, highly recommend reading that. If you read one thing in that bibliography, read Sisson's autobiography. It's great. He's a very independent-minded guy, and he takes his appointment very, very seriously. And from the outset, he does not feel constrained by the practices in Southern courts. He was a lawyer in Alberta before he came up, Northern Alberta, but he doesn't feel trapped by that, and he certainly realizes that he now has the room to make this his own court, and he does. And he makes sure to push back against Ottawa every time they try to influence a decision or appeal a decision or try to affect what he does. If you talk to anybody who appeared before Sisson's, Judge DeWard, or any of the other lawyers from that time, they will all tell you about Sisson's references to the bright boys in Ottawa trying to interfere with him and his court system. Sisson's sits on the bench. He's the first judge. He sits on the bench for 10 years, and he's followed by William Morrow. William Morrow was another lawyer from Alberta. He had appeared before Sisson's many times as counsel, and he very much follows in Sisson's footsteps. I don't mean to suggest that Bill Morrow was not his own man. Again, in my bibliography, I include his autobiography as well. Again, some very, very interesting cases, a very, very interesting era of this court. But he very much continues in Sisson's tradition, very much pushing back against Ottawa, very much adapting as much as he can the law that he has to apply to the realities of the people to whom he applies it to. And these two are really responsible for the modern Supreme Court. It's not just the legislation, it's not just the data reception, it's not just bringing the law and the institutions in line with what we conceive of as to be a modern court. It's these two men who really take that and say, okay, let's do something with this. And they make it, in my submission, a very different superior court than what you see in the southern provinces. The court expands. I mean, Morrow is followed by subsequent judges, and it gets bigger. If I may be so bold to suggest, I would say that it continues, in the Sisson's and Morrow tradition, it continues to adapt to changing territorial realities. I don't know that you're going to see the kind of profound constitutional changes that we've seen from 1670 to 1955. I think in the Northwest Territories, with the Supreme Court, Territorial Court, and the Court of Appeal, I think that evolution is more or less complete, at least from an institutional standpoint. I think the final step of that court, the final step in the evolution of that court, was the creation of the Nunavut Court of Justice in 1999, when Nunavut was created as a new territory. There were a range of possibilities available for the new courts of that new territory. They could have stuck with what they had inherited from the Northwest Territories. However, they chose to go a new way, and they created the Nunavut Court of Justice. That's a fused bench that combines the superior and the territorial courts with a separate Court of Appeal. So I think that's, from an institutional standpoint, I think that's the last of that kind of a change we'll see up here or in the Northern Territories. Who knows? What we have seen recently are new roles and jurisdictions identified for the NWT Supreme Court and the other courts up here. If, for example, you look at the comprehensive land claim agreements and the self-government agreements that we now have in place in the Northwest Territories, there is a concurrent jurisdiction with the federal court under those agreements for various matters that arise. Under the Mackenzie Valley Resource Management Act, which is a system of environmental assessment and land and water regulation that came out of those comprehensive land claims, the NWT Supreme Court is given exclusive jurisdiction over administrative law matters arising out of the various boards and processes created under that legislation. I think you can draw a link from judges like Sissons and Morrow to that grant of jurisdiction in the MVRMA and in the comprehensive land claim agreements. In a previous life, I was counsel for the government of Northwest Territories and represented them during the negotiation of the Tlicho Agreement, which, like the other land claims, creates these new roles and jurisdictions from the NWT Supreme Court. And I definitely got a sense that unlike a lot of government institutions, colonial institutions that were imposed on Aboriginal people in the Northwest Territories and elsewhere in Canada, and I realize this is presumptuous of me to say, but I think Aboriginal people in the Northwest Territories have a degree of comfort and familiarity with that court that they might not otherwise have had it not been for judges like Sissons and Morrow. When you look at some of the more historic decisions that Sissons and Morrow made, and those are gone into detail in their autobiographies, they are very, very much trying to adapt law to the reality of Aboriginal people and Aboriginal life up here. And I think Aboriginal people understood that, and I think that they see those courts as more relevant to them, I guess. And I think you do see it reflected in acts like the MVRMA and the comprehensive land claims. Again, those courts are not displaced or replaced by something else. They are simply given new jurisdictions and new subject areas that they can now make decisions with respect to. They will have other roles as more land claims are settled, as more self-government agreements are settled, as new government to government relationships evolve in the Northwest Territories. There will be new roles for that Supreme Court. I'm going to close now, and as I mentioned earlier, as I said, I think if there was a theme to this presentation, it's been this absence of mind with respect to the evolution of law and legal institutions up here. There is never really any deliberate plan or design for any of those. No one ever actually ever sat down, I don't think, and tried to plot out what this evolving territory needed in terms of law and legal institutions. However, I'm going to suggest that we may be better for that, and our law and legal institutions may be better for that. As I pointed out, it gave lawyers and judges like Sissons and Morrow room to push the boundaries up here and room to shape those legal institutions in ways that they otherwise may not have been able to do. I think those changes are still taking place. I won't be around years from now to give any sort of presentation like this, but I hope someone is. And if I'm still around, I'll be quite interested to hear what further changes have taken place. So that's That's really all I have to say. I did want to leave some time for questions and discussions.
So if anyone has any questions, you can either type it into the Zoom group chat, or you can raise your hand and we'll unmute you. Okay, well, thanks, Scott. I don't see any questions coming through. Thanks very much. And as previously, this presentation will be uploaded to the LSNT YouTube channel. So thanks very much, everyone, for coming, and see you next time.
Thanks, everyone.
Thanks, Scott.
Thank you.
Thank you.